One of the most common misconceptions that I hear about revocable living trust is that people think that once they sign it, their job is done, the work is over. That's not true. Just creating the revocable living trust by it in itself is not going to avoid probate. Creating the trust is only the first step. You have to do step 2 if you want your estate to avoid probate. I regularly meet with families where the decedent created a trust in order to avoid probate, but only to discover that many of their assets were never actually put into the trust, thereby requiring a probate. So in this video, we're going to go over that step 2, what you must do to ensure that your estate avoids probate if you're using a revocable living trust. I'm Darcel Lobo, an estate planning attorney in the Seattle area, kind of by SeaTac Airport in Normandy Park, and I've been helping clients for the past 17 years with wills, trusts, power of attorneys, real estate, and today I'm going to walk you through the 5 assets you must ensure get into your revocable living trust. Let's get into it. Number 1 is your home, or really any real estate you own, whether it's a single family home, a condo, a townhome. If it's a vacant lot of just a parcel of land, we have to ensure you get those deeded into your trust. Even if you're not the sole owner, maybe you're a fractional owner, maybe you own half and someone else owns half, or thirds, or some other distribution, we have to make sure any real estate interest you own gets into your trust if you want it to avoid probate. Because deeding it into your trust is what allows your successor trustee to then distribute that asset or list it for sale, whatever they're going to do with it, whatever your trust says. It allows them to do so through your trust because your trust owns it. If you have real estate that you have not deeded into your trust, you need to call an attorney immediately to get it deeded into your trust. If you don't, it's probably going to go through probate. And we're talking again, all kinds of real estate, the home that you live in, vacation properties, rental properties. If they're in your LLC, it's a different conversation, but one that we still need to address. Or out of state real estate. A lot of my clients have a home here in Washington and they have a second home. Arizona is really popular, New Mexico, Hawaii, California. It's pretty popular states for my clients to have a second home. We have to ensure we get those properties into your trust as well. Number 2, non-retirement investment accounts. We're talking, Fidelity, your Vanguard, your Schwab, brokerage accounts, investment accounts. We have to make sure that those get into your trust. And we can do that one of 2 ways. You can either retitle the account into the name of the trust or name the trust as a beneficiary. I usually defer to the financial planner as far as which one is the preferred option for the client, but either one works as long as we do one of those 2 options. And again, this is going to help ensure that things are seamless and that the accounts get into your trust upon your passing and can be distributed without going through probate. And for some of you, you may have had these accounts for years and have old beneficiaries named that we needed to update anyways. So we'll make that update and make sure we get your trust onto those accounts. Number 3 are bank accounts. We're talking checking accounts, savings accounts, CDs, money market accounts. Like number 2 for your investment accounts, we also want to ensure that these accounts are either titled in the name of the trust or the trust is named as beneficiary. Now, for your checking and savings accounts, if you are using these regularly and you're writing checks and have a debit card, retitling the account into the name of the trust can be a little bit burdensome because you have to get a new debit card and get new checks written, and maybe even a new account number at some banks sometimes. So the easier option, the one that I suggest for these types of accounts that you're using on a regular basis, is just to ensure the trust is named as a beneficiary. That way, during your lifetime, the account is still in your personal name, but upon your passing, it goes to the trust, and the trust controls what happens to the account. Again, it makes things easier. It keeps things seamless for your successor trustee to be able to have access to those funds immediately and not have the accounts be frozen, to let them get into the trust right away and then be distributed as the trust says. And this should be pretty simple and straightforward to do. Your bank should be very familiar with this. This shouldn't be anything new or surprising to them. I tell all my clients, if we have done your estate plan for you, have your banker call me if they have any questions or any issues. It's very easy to get the accounts updated to have the trust named as beneficiary. It should not be a problem. It might take a few minutes of your time walking into your local branch, but otherwise should be a very easy process. All right, we're on number 4 now. Now we're talking about business interests. A lot of my clients have LLCs, whether they're self-employed or they have side jobs that they do under an LLC. Maybe they have investment properties in their LLCs. For a wide array of reasons, a lot of my clients will have LLCs. And we want to ensure that that interest gets into the trust as well. And so what we do with that business interest is that we assign the interest into your trust. Now, first we have to make sure that you have an operating agreement and that we review it to make sure we are in compliance. Sometimes some operating agreements already have provisions as to what happens when a member passes away. So we have to review that and ensure that what we're doing with your trust is consistent and in compliance with what your operating agreement says. Assuming it is, we will do an assignment of interest, getting your interest in that LLC into your trust, again, to allow the liquidation of the LLC and the assets distributed to the trust, and then as your trust provides for your heirs. Okay, number 5 are personal property items. So we're talking your household goods and belongings, your jewelry, your antiques, your cars, your RVs, your boats, personal property. What we do here at our office is called a personal property assignment. So that just because we've done a trust for you, you don't have to go and retitle all of your cars. And every time you buy and sell a car, it has to be retitled. That's not what we do. We do a personal property assignment that takes whatever personal items you own at the time of your death, go into your trust. That way you're not having to re-update all the titles. And for a lot of the property, they won't have titles, right? Like some jewelry items or family heirlooms or antiques. So that personal property assignment takes all of your personal property and puts it into your trust. We include that with all of our trust packages for all of our clients. And especially if you have some sizable personal property assets, right? When we're talking about jewelry, or some clients have various collections like coin collections or other collectibles, we want to ensure that all that gets into your trust so your trust can control what happens to it. If you remember only one thing from this video, let it be this. Creating your revocable living trust is only step 1. There is a 2-step process here. You also need to do step 2, which is funding your trust, getting your assets into your revocable living trust. Once you've done step 2, then your job is complete with the revocable living trust. And if you're not sure if you have funded your trust with all of your assets, you're probably going to need to make some phone calls to your bank, to your financial advisor, checking beneficiary designations. We want to make sure we get all this straightened out now. I know it may take, 30 minutes or an hour or so to get all this straightened out, but believe me, you're going to be so thankful that you do when you realize that you have a beneficiary name from 20 years ago, from 30 years ago, that you don't want to be on that account anymore, and ensuring that it all gets into your trust. And if you found this video helpful, please make sure you subscribe and stick around. We talk about all things estate planning and probate over on this channel. If you want to learn more about funding your revocable living trust, make sure you watch this video here where I break down how to fund your revocable living trust. Thanks for watching, and I'll see you in the next one.